Hello everyone and welcome to the Bird and Bird International L&E Club. In this podcast series, we will hear from our international team of employment law experts on a variety of cutting-edge topics. Each episode will provide 5 key takeaways on a key L&E theme with a US focus in 10 minutes. I'm Patty Walsh, a US-based partner within the L&E group here at Bird and Bird, and I co-head our San Francisco office. Today, I'm delighted to introduce you to one of my favourite partners, Tim Spillane, who leads the employment team in our London office. Tim is going to be sharing his thoughts today on how you as an employer can protect your business interests against employee misbehaviour across the world. Over to you now, Tim.
Hi, Patty. Well, thank you very much for that introduction, and it's great to be here on this podcast. Yes, employee misbehavior can clearly take a very wide variety of forms, but what I want to focus on today is misconduct relating to competitive behavior by employees against their employer's business interests. And this can be very damaging for companies in a number of ways, including the possible loss of staff, clients, or customers, and confidential information and trade secrets. And of course, reputational damage, both internally and externally, and financial loss and wasted management time. So there are a number of potential risks. And this, of course, has always been an important issue for employers, but has been a particularly hot topic in recent years with the impact of the pandemic and the modern workplace moving away from the traditional 9 to 5 office commuter model towards hybrid systems and remote working. And this has meant reduced face-to-face engagement between companies and staff, with sometimes weakened bonds of loyalty between employee and employer, and higher turnover of staff. And this has increased the risks of employees disclosing confidential information when they're using their own devices, for example, or working in public places like cafes or co-working spaces, and where third parties can eavesdrop on calls or take photographs of laptop screens. And also employees may be using insecure public internet connections. Employees are also taking workplace information between the office and home much more regularly, whether that's hard copy or electronic form. There's an increased likelihood of data being lost or stolen. And remote working also provides an increased opportunity for staff to leak business sensitive information, such as client details or pricing strategy, whether that's deliberately or by accident. So what I'd like to do now is discuss 5 practical ways in which companies can seek to protect their businesses in these areas, given the environment we've just spoken about. And point number 1 is that robust employment contracts, policies, and procedures are the starting point. In most European and Asia-Pac countries, the key tools available to protect the employer are express wording in the employment contract and relevant HR and compliance policies. And these would normally deal with confidential information, intellectual property, and any post-termination restrictions like non-compete clauses or non-solicitation restraints. And we'd always recommend clients to regularly review their template employment contracts and relevant policies like employee handbooks, compliance manuals, and IT security procedures, and ensure that these are kept up to date and reflect the realities of the new world of remote and hybrid work. It's also important to keep on top of any changes in the law in the countries in which you operate. For example, in a recent UK case in the life sciences sector, a confidentiality clause in an employment contract was found to have been drafted too widely to be enforceable, and the company was therefore unable to protect all of its proprietary information. Also, in certain circumstances, so for example, where employees are working in particularly senior or sensitive roles or on certain projects handling highly confidential information, then in addition to protection under the standard employment contract and relevant policies, you may also think it's appropriate to require employees to sign separate non-disclosure agreements, so NDAs, to cover the matter in question. We find this can serve to focus employees' minds on the importance of maintaining strict confidentiality in specific situations and act as a deterrent against potential breach. So point 2 is that we recommend companies conduct a regular audit and risk assessment of their business's confidential information and trade secrets. And that should include the scope of such materials and where they're held. And also worthwhile keeping a record of who has control and access to such materials, and making sure confidential documents are labelled as such and are not for external disclosure. Turning to point 3, and this is that employers should spend time educating staff about these issues through regular IT and compliance training, including on, for example, the importance of data security and the distinction between personal and corporate devices, as well as employees being vigilant in relation to phishing scams. As time goes on, employees may also forget what they've signed up to in their contracts, so it can be worthwhile reminding employees annually of the existence and importance of their existing contractual obligations. Point 4 is that more and more businesses are using technology to monitor employees' IT use, and this can be effective at immediately identifying potential breaches or issues to consider. So, for example, irregular patterns of behavior, including big downloads or a spike in emails to personal accounts, or large volumes of printing, particularly around the time of employees resigning. In most countries, monitoring systems like this will be subject to data protection safeguards, including whether there's a legal basis for implementing the system and any notification and consultation requirements. And organizations should also be mindful of any employee relations impact of introducing these tools. So finally, point 5 is for employers to have clear offboarding procedures. And there are a number of measures that employers can adopt as part of the offboarding process when an employee leaves the business. And these may include written reminders to employees of their contractual obligations, requiring them to confirm that they've returned all company information and property, and that they'll comply with their post-termination obligations regarding confidentiality, intellectual property, and post-termination restrictions. And as far as possible, we'd recommend devices and information should be returned by hand rather than by post to avoid the risks of them being lost in transit or not being directed to the right person or the teams once they're delivered. Where permitted under the employment contract or local law, putting a departing employee on garden leave, in other words, where they remain employed but are suspended from any active duties, can be an effective and simple way for the employer to restrict an employee's activities during a notice period after they've resigned. Depending on the country and wording of a contract, garden leave may be what we call offset against the length of any post-termination restrictions. So, for example, if you have an employee who has a 3-month notice period spent on garden leave and then a 6-month non-compete, then once the 3 months of garden leave has finished, there'd only be 3 months of the non-compete left. And this can act as an alternative to relying on post-termination restrictions, which can be helpful, especially if the restriction might otherwise be difficult to enforce. Local variations always need to be taken into account when handling these leaving arrangements. So, for example, in Hong Kong, employees can buy out their notice periods, which should be borne in mind if you were looking at garden leave provisions. And some organizations also tie the payment of deferred compensation, such as stock options and bonuses, to employees' compliance with ongoing confidentiality duties and post-termination restraints after they leave. And linking pay remuneration in this way can, in our experience, be a very effective deterrent and reduce the risk of breaches occurring. In some cases, it may also be appropriate to write to the new employer if you know where the departing employee is going, to ensure that they're also aware of an individual's post-termination obligations. And in a contentious scenario, that may provide support for any subsequent claim you wish to bring against a new employer for inducing a former employee to breach their contract. So there we have my 5 points, with what I hope are practical takeaways for employers of all types across different sectors to consider when looking at this issue of business protection. And thanks very much again, Patty.
Thank you so much indeed, Tim. It was fantastic to hear your practical pointers. Just a couple of comments from the US side. There's a great debate going on at the moment about the appropriateness of non-competes. And I think what your presentation has shown us is that there are a myriad of different ways to protect business interests beyond non-competes if they happen to be unenforceable. The focus on confidentiality, perhaps using garden leave, NDA links to complying with obligations, etc. And I think the other takeaway for the US audience is that actually you can rely on non-competes in many jurisdictions. It really does depend. Thank you for listening to today's podcast. We hope you join us again and look out for more content coming soon.